Good morning. We're a little before 9, but 4, but I think we'll go ahead. Good morning to everyone at today's public hearing of the Prosecutor Vetting Commission. This hearing is being conducted virtually using the Zoom platform. I am Christopher Lehman, chairperson of the commission, and I declare this session to be open. This is an additional hearing for Sergiu Besliu, a candidate for the Superior Council of Prosecutors Selection and Evaluation Board. The initial hearing for Mr. Besliu was conducted by this commission on the 28th of March, 2024. Mr. Besliu, welcome. I'll note for the record that the commission is established under Law 252 on the external evaluation of judges and prosecutors. Article 22, paragraph 13 of that law, excuse me, provides that this commission will assess candidates for the Superior Council of Prosecutors Selection and Evaluation Board according to the procedures and criteria regulated by Law Number 26, 2022 on measures related to the selection of candidates for the positions of members in the self-administration bodies of the prosecutors. Today's hearing is being conducted under the Commission's Rules of Procedures for Evaluations under Law Number 26, 2022. I'm joined by my 5 colleagues today at the hearing, Nadezhda Hryptievsky, Cornel Lebedinsky, Ermontis Mikalonis, Virginia Mararo, and Saskia de Vries. The Commission is also assisted by members of its Secretariat. This hearing is open to the public and members of the media. The hearing will be conducted with interpretation into Romanian and English. I note additionally that the proceedings are being recorded. The recordings of the Commission's public hearings will be available online on the Commission's website within 3 days after the hearing. Mr. Besliu, I note that the Commission previously sent you 4 rounds of questions to which you responded. Additionally, the Commission held a previous hearing, as noted, on 28 March 2024, which you attended and at which you answered questions. Finally, the Commission sent you an additional post-hearing round of questions on the 20th of May 2024, which you answered in a timely fashion. On the 13th of August 2024, the Commission invited you to attend today's hearing, and at that time we notified you of the specific topics to be addressed at the hearing today. Mr. Besliu, thank you again for appearing today. I'll begin with our questions for you. We ask you to respond in a complete and truthful manner to the questions. First, let me ask you if you wish to make any additions or corrections to any of the answers you've previously provided to the Commission's request for information, either in your most recent response to the May questions or to anything that was submitted earlier.
Bună ziua, onorat comisie. Ceva suplimentar sau
esteemed commission.
Deja le-am oferit comisiei în toate rundele de întrebări-răspunsuri, inclusiv și din runda post-audiere.
So with respect to all of the answers that I provided to the commission in prior rounds and post-hearing rounds, I have nothing to add. So I hold to what I declared, what I provided in the previous rounds of questions and answers.
Thank you. And then just to clarify, I want to ask if the answers that you provided in your 5-year declaration and ethics questionnaire, which was returned on 27 December 2023, if those all remain accurate as of today.
Da, nu sunt careva modificări, sunt în vigoare.
No changes. They are valid as of today as well.
Thank you. I will now yield the floor to Ermontis Mikalonis of the Commission. Ermontis.
Thank you, Mr. Chairperson. Good afternoon, Mr. Besliu. So first of all, I would like to thank you for already provided information to the Commission, but we still have some questions for you. So we have prepared 4 groups of questions for you. The first group of questions related to the purchase of the car model BMW 520D in 2017. According to information available to the Commission on 13th March 2017, you concluded a pre-sale purchase agreement with a limited liability company and made the first payment for the amount of 40,000 MDL on 16 March 2017. Under the pre-contract, you as a buyer intended to obtain and the machine company sell you a vehicle model BMW 520D, the year of manufacture 2013, black in color, in good functional condition and injured. The sale price of the car was set at 22,000 euro. The seller declares that the vehicle will be brought into good functional condition without material defects. The deadline for concluding the sale purchase agreement was 28 March 2017. Is this information correct?
Да, я confirm.
Yes, I confirm.
Thank you for your answer. It was also agreed that if the seller refuses to conclude the definitive contract or will not fully and timely fulfill its obligation under the pre-contract, it undertakes to pay you a penalty of 1% of the price agreed in the pre-contract for each day of delay. Is this information correct?
Да, есть коррект, конформ пункту
Yes,
4.3
it is
aligned
correct
contract.
according point 4.3 of the pre-contract pre-agreement.
Who proposed such penalty amount, you or the vehicle seller?
Deci, eu, în calitatea mea, eu sunt și avocat la toate și
I am
evident că
also
am vrut să mă
a
asigur în
lawyer,
privința la o
so I
tranzacție
wanted
și am
to make
introdus
sure
la
to be
inițiativa
sure
mea această
related to
penalitate,
a transaction. So it was my initiative to add this penalty, and it was agreed by the parties in case of failure to fulfill the contractual obligations that were to be fulfilled by bringing a car to Moldova in the condition that was described in the pre-contract. So to this end, I suggested that item of a contract, and the company agreed, and we signed the contract having that clause included.
Thank you for your answer. How do you assess whether a fine of 1% of the vehicle price or 220 euro per day is fair and reflects the market rate interest rate?
Da, deci, mulțumesc pentru întrebare.
Thank you for your question. We need to make a distinction between the penalty and the interest. The interest, according to the civil code, is the legal interest established according to the civil code, but the penalty is a prejudice anticipated by the parties related to the fact that if parties fail to fulfill the obligations, they are subject to a penalty. So penalty is agreed between the parties, can be 0.5, 0.7, 1%, or even more. In our case, the company, we decided that it was fair, it was correct, because we negotiated, well, not negotiated, but we agreed on this penalty, 1% penalty with the company. I think it was a penalty that was not opposite to contractual customs among economic operators, and it is a penalty that is acceptable, that was agreed by the parties, and that in case of failure to fulfill obligations by the company could have been charged from the company as a prejudice, a damage caused, as a penalty.
Thank you for your answer. On 24th of July 2017, you concluded a sale purchase agreement with a limited liability company. The price of the car with the parameters indicated in the pre-contract was set at 355,000 MDL, estimative 60,800 euro, less than it was stated in the pre-contract. At the same time, it was agreed that 150,000 MDL would be paid on the date of signing the contract, and the rest of the amount until 24th August 2018 in 13 monthly payments. Is this information correct?
Da, le confirm.
Yes, I confirm.
Why did the vehicle seller agree to reduce the price set in the pre-contract?
Deci, cum și-am menționat în runda de
As
răspunsuri,
I mentioned in the questions and answers round, the car came with certain deficiencies, and the final contract was not concluded for half a year, and the penalty was getting quite high. And in that case, we agreed with the company that the most accurate price that should be included in the invoice and in the contract should be established by an evaluation company in Moldova that would establish the final price to give an evaluation of how much does this car cost. So we contract Lara company. It has evaluators in all fields, including movable goods. And Lara company, both pre-vetting and vetting commission, were requesting information from that company oftentimes, so which means they recognize its competence. And on 19th of July, they issued the evaluation report that said the final price of the agreement is 355,000 lei. And on 24th of July, some days later, that amount was added to the contract, and we got a final contract regarding that car with a fair price set by the evaluation report in 2017. That report probably can be requested from Lara company. They may have it in their archive. My purpose was to avoid possible further hidden deficiencies of a car, to avoid additional expenses later on. So we wanted to find common ground and conclude a final contract. So one of the conditions was to contract Lara company, which is an evaluation company with good reputation in Moldova. So this evaluation report was drafted, and the final price was the one set in the evaluation report, both in the invoice and in the contract. That is what I can say.
Thank you. Did you pay the first installment on 150,000 MDLA on 24th of July 2017 and other payments from 2017 to 2018 as agreed in the sale purchase agreement?
Nu, deci datorită faptului că
because of the fact that the car had deficiencies, we agreed with the company to make installments of payment. So I did not pay 150,000 lei. I only paid only that advance payment of 40,000 lei. And because of the deficiencies of the car, we agreed to defer the payments even more. And as I mentioned in the questions rounds with this company, I've had a collaboration over time. We had a really good collaboration with this company. I became friends with the director of that company, and we agreed to defer, to postpone the payment for that car. And to this end, yes, I did not pay according to the contract. I asked for a payment vacation from the company, and that company was in a financially good condition, so they could afford this deferral of payment.
Thank you. How do you assess your behavior in the case of non-compliance with obligations set out in the sale purchase agreement?
Deci eu consider că eu am avut un
believe that I behaved with good faith, and I will explain that in more details, make more clarity, because as I was saying, that contract had two annexes signed, annex number 1 and number 3. Both of them were about that payment postponement. First one was because I could have asked for a penalty because the car was with defects, and it was agreed that the payment would be made in installments. And then annex number 3, in the context of our personal relationship with the director of the company, it was agreed for the installment to be made until 2023, and I did not want to keep paying until 2023. End of 2023, in July 2023, I paid, finished paying for that car. I didn't get any discount or facilities. I paid for the car according to the invoice, but I paid for it later. As I mentioned, mentioned in the
am solicitat
answers
o vacanță
round,
temporară de
I
la
asked
administrator
for a
datorită
payment
faptului că
vacation
acumulam
from
fonduri
the
financiare pentru
manager
procurarea
because
unui imobil.
I was
Imobilul
saving money
respectiv
for
mi l-am
buying the
procurat
real
în anul
estate. So I
2021,
purchased the real
și
estate in
ulterior, din
2021,
2021 până în
and
2023, am mai
subsequently
acumulat
from
surse financiare
2021
și
until
într-un final
2023,
am
I gave
optat
it
să mă
some more
sume. Deci
financial
eu nu
resources
văd
and I
o
paid for the car.
contradicție cu norme
I don't see
deontologice
any
a avocatului sau
contradiction
cu
with the
normele deontologice
deontological
dintr-o
rules for
profesie juridică,
lawyers
ori
or
am
any
avut un contract,
deontological rules for
contractul
legal
în final a fost
professionals because we had
respectat.
a
Mai
contract,
mult,
the
toate
contract was
achitările
fulfilled
respective,
in the end.
automobilul în
Moreover,
luna
the
iulie,
payments
deci au
for the
fost
cars
până
in
la
July
demararea
were
procedurii de
made
evaluare mi-a sau să aibă
before
legătură cauzală,
the
eu să mai
evaluation of
ceva
me,
de
the
gen
subject
absolut
started. There was no
de fiind de bună credință, conștiincios,
connection
am
here. So
achitat
I
acest
was really
automobil, într-un final
acting in good
se,
faith. I paid for the
deci,
car,
nu
and
consider că am
I don't
încălcat câteva
believe
norme
that I
deontologice sau nu am
violated any
respectat poate fie sau
deontological
alt
rules
contractul
or that I
care, deci
violated
a fost
the
încheiat
contract
cu
in any
compania
way,
respectivă.
which
Mai mult
was
ca atât,
concluded
această
with the
amânare
company.
a fost
Moreover, this
convenită de părți
postponement
și
was
a fost
agreed by the
deci
parties.
agreată de părți în cazul
It
respectiv.
was
Partea care a admis această
agreed by the
vacanță de
parties,
plată,
and the party
reiterez
that
că nu a avut
allowed this
careva
payment vacation did not
probleme financiare.
have
Compania
any
respectivă, având venituri din
financial issues
2017,
because the
modalitate
company
comisii
had
din
incomes.
2017 până în
I provided to the
2022
commission from
venituri în jur
since
de 3-4
2017
milioane
to
profit net,
2022,
deci
that company had
anual,
around 3-4
deci nu
million
era o problemă
lei
să facă,
profit
deci să
per
permită
year.
această vacanță de
So
plată
it
în
wasn't
adresa
a
mea,
problem
de
for them to
vacanță de
afford having
300.000
this
de lei, raportat la
payment
4-3-4
deferral of
milioane profit
300,000
net anual
lei
care
compared to their
înregistrat
3-4
companiei
million
respective. Deci
lei
nu văd
of
o
net profit that the
contradicție în
company was
careva
getting. I
norme
don't see any
deontologice și
contradiction
consider că,
with
până la
any
urmă, deci
deontological rules, and
eu
I
sunt de bună credință,
believe
am
that
achitat
I
bună credință acest
uh,
automobil și
acted in
nu
good
am,
faith. I paid for
deci
the
nu am
car in good
beneficiat de nicio
faith,
reducere.
and I did
Și
not get
sunt
any
corect, am fost
discount,
corect cu
and I
compania
was
respectivă. Mai
correct
mult ca atât,
towards that
o
company.
declarație în acest sens a
Moreover,
fost scrisă
a
de către
declaration
însăși
to
directorul
this
companiei în
end
cauză,
was
două
written by
declarații, și
the
am prezentat
company,
comisiei
actually
prin
two of
care
them, and I
confirmă
submitted
faptul
them to
activării,
the commission.
confirmă faptul
He
că nu sunt
confirmed the
careva pretenții
payment. He
patrimoniale în
confirmed that
privința
he
mea.
has no
Confirmă
property
faptul
or
că mașina
financial
achitat în
claims
momentul
towards
respectiv
me.
fără
He
nicio
said
problemă.
that at this point or until now the car has been paid for. No problem.
Thank you for your very detailed answer. So on the 1st September 2018, you signed a new annex, as you mentioned, to the sale purchase contract, according to which the seller agreed to postpone the payment of the rest of price of 315,000 MDL until 31st December 2023. The deferral of payment was agreed upon interest-free. This information is correct?
Da, deci nu a fost aplicată dobândă
Yes,
la aceasta, a fost iarăși
no interest was
deci am
applied
agreat
again. We
anexa
agreed
respectivă,
on
deci
that
cu directorul
annex
companiei în cauză,
with the
cum am
director of the
menționat,
company.
nu erau
As
careva
I
situații
mentioned,
dificile financiare în
they
această
did not,
companie, mai mult ca
the
atât am
company did
convenit
not
cu
have
directorul că în
financial
cazul în care
difficulties,
compania
and
respectivă va
agreed
avea
with
nevoie
the
de acești
director
bani
that
în
in
mod urgent,
case
eu voi
if the company
eu
needs the money
voi achita
as a matter of
imediat această sumă
urgency, I
fără
will
nicio
pay the
problemă,
amount
prețul
immediately,
credită în cazul în care nu voi dispune de mijloace
even if
financiare.
it meant that I had to contract a loan if I wouldn't have the money at a point.
You already answered in these questions, but maybe you will provide some additional information. So why did the vehicle seller agree to postpone payments for 5 years and the deferral of payments was agreed interest-free? Maybe some additional comments from your side.
Da, eu vă explic. Suplimentar, vreau să
I am
menționez că
going to
eu, la
explain.
rândul meu,
Additionally, I
când am
would
avut
like to mention
posibilitatea
that
să aplic o
when
penalitate,
I
eu nu am
had
aplicat. În
the
cazul
possibility to
respectiv, a
apply the
fost iarăși de
penalty,
comun acord
I
stabilit
did not
cum se
apply it.
aplice
So in
dobânda.
this
Mai mult ca
case,
atât,
it was agreed
dobânda,
again
iarăși,
by
este
the parties
un
not to
acord de
apply the
achitat. Dobânda
interest.
urmează a
The
fi
interest
stabilită la
is
acordul
agreed
părților.
upon by the
Dacă
parties,
nu,
so it's
părțile
supposed
nu
to
au
be
convenit
established as agreed by parties. And if the
plătească o anumită
parties
dobândă, deci
don't agree on
contractul poate fi
establishing
făcut gratuit, în
the
sensul nu
interest,
că
it
gratuit,
can
dar
be
în sensul de a nu avea careva beneficii suplimentare companiei, să nu fie
the
titlul oneros în
agreement
sensul
could
dobânzii
be
sau
without
penalității,
any
să treci
additional
dobânda
financials,
bancară.
not to have
Deci,
this
în cazul
other
respectiv,
financial
nu
matters
am
like
convenit ca să nu fie
interest
nicio
or
dobândă
penalty. So we
și
agreed
o amânare
not
de
to
plată,
have
ieșind
any
din
interest, just a
circumstanțele
payment
personale
deferral
mele care le-am
based
bazat
on my
pe
personal
i-am
circumstances
solicitat
that I
directorului
asked the
să
director
intre în situația mea.
to
Eu
understand my situation because I was saving financial resources to purchase real estate, and those financial resources could the Commission saw during the years 2016, 17, 18, 19, 20, 21, including with euro withdrawals from the ATM, from my attorney fee. It's all chronological. All those amounts explain what I was saying right now. I gave it money to buy an apartment, and then since 2021 to 2023, I sent money to repay the debt for the car, and I paid it in 2023. So there's a chronology of all the events that I'm explaining now. I don't see a problem with having no interest applied, because an interest is supposed to be agreed by the parties. And again, the director of this company mentioned in one of the statements that was provided to the Commission that the parties agreed not to apply interest and to allow this deferral of payment. And I reiterate, that was based on the financial situation of the company that was favorable. It had a net profit of 3-4 million lei per year. I have a statement from the tax authority. I submitted them to the Commission in the last round of questions and answers post-hearing. I showed that the company could have it. They understood my situation, and it was justified. The company was not in insolvency, it was not at a loss, but it was in a good financial condition. That's why having a 3-4 million profit, they could afford a deferral of payment of 300,000 lei for me. Moreover, as I said, I paid the amount in July in good faith, in full, so there are no claims from that company.
Thank you. In your opinion, was the contract economically reasonable for the car dealer?
În primul rând, iarăși, eu voi aduce
First of all,
referitor
again,
la
I am going
dobândă
to to make the arguments about the interest and the penalty that I did not ask for. Speaking about reasonable nature, that was an agreement between the parties, me and the company. And when I had the possibility, I did not request the penalty. Later on, they did not ask for interest and allowed the deferral of payment. And that was also based on the personal relationship between me and the director of the company. And to this end, I would like to give an example, a decision of Vetting Commission number 26 in March 2023, passing a candidate. It was about a donation of 9,000 euro from a friend to buy a car. In my case, it wasn't a donation, it was only a deferral of payment, and that payment took place in 2023 in full. If the car wouldn't be paid for by now, or wouldn't be paid by the time when the vetting started, then there could be questions about my good faith. But it happened before, so there are no questions about my good faith. I fulfilled my contractual obligations to that company, and I paid for the car in full. And the fact whether it is a contract that is reasonable or not from an economic point of view, the company was not looking for economic benefits, because they were in a good financial condition at that time, with a net profit of 3-4 million lei per year that could be distributed as dividends to the founders. So they had net profit of 3-4 million. I reiterate, it wasn't a problem for the company to accept this deferral of payment given the financial situation of the company.
Thank you. Anyway, what did a company get in exchange for the substantial deferral of payments?
Deci, cum am menționat, prima
As
amânare
I
a plăților
mentioned,
nu
the
era
first
necesar să
deferral
obțină
of
ceva.
payment
Prima
was,
amânare a plăților
well,
a
they
fost
did not necessarily
datorită
need to get
faptului că
something
acum
from
am
that.
fost
The first
defecte
one
și
was
au fost de acord,
because of the fact that
deci să
the
amânăm
car
această
had some
plată
defects
și
and they
imediat
agreed
atunci am stabilit
to
relații de
defer the payment,
colaborare
and
între mine și
that's
compania
when
respectivă, de
immediately we
reprezentare
established a
în calitate de
collaboration
viitor, în calitate de
relationship between me and the
În cursul
company to represent the
desfășurării
company in the
activității
future as an
companiei
attorney.
respective, deci am
And
împlinit
during
cu
doing the work, I became friends with the director of the company, and the third annex was determined by the friendship between me with the company director, who understood my situation. I needed liquidities to save for the apartment, and he agreed to postpone through Annex 2 until 2023. So he was not after financial benefits or obtaining or not obtaining something. Again, I reiterate, thanks to the good financial condition of the company, the company afforded such a conduct in relation to me. As I said, they had good income. They could afford this deferral of payment with respect to me without any interest.
Thank you. In your written communication with the Commission and today, you explained that after concluding the sale purchase agreement on 24 July 2017, you agreed to establish with the company and represent it in the future civil litigations. You have several civil cases in which you represent the mentioned company. The total revenues for the period from 2017 to 2023 amount to about 97,000 MDL. Is this information correct?
Yes, it is.
In your opinion, did the deferral of payment by the company also involve any favors or concessions from your side, such as reduced price for legal services offered or something else?
Well, I can say with certainty that it did not involve any discounts whatsoever. They have paid the honorary as per the agreement that we had for those particular cases. So there was no causal link between the deferment of payments that for that car and the fact that I was representing that particular company in court. So there was no link between them. This company has paid the fees, my fees, on the basis of the action I was undertaken, representing them as per the agreement. There was no concessions whatsoever for this company for the fact that I've bought that car.
In the post-hearing communication with the Commission, you were asked to indicate how much you saved by deferring payments until 2023 and not paying interest for late payments. You explained that according to your calculation, the amount of possible legal interest would be about 160,000 MDL. Is this information correct?
Yes, that is correct.
So thank you for the first group of questions. Maybe do you have something to add or clarify concerning this issue?
With regards to the last question, that there's been this saving and for the interest of the 160,000, that was an estimation. Again, I would like to state that I could have established a penalty, for instance, of 500,000 if the contract was not fulfilled and if I insisted on that. But in this case, the 160,000 interest, that is what I've calculated more or less as part of the rounds of questions and answers. So that's the last addition that I have.
Thank you for clarification. Maybe other Commission members have questions regarding this issue.
Yeah, I'll jump in with one if nobody else does. Mr. Besliu, it's a very strange situation where there's a contract dispute and it results in the parties becoming friends. I'm not saying there's anything wrong with that, but it's very strange. It's a very adversarial situation when you buy a car, the car's defective, and you go back to the seller and they basically say, oh yeah, never mind. I'm just wondering if you can explain to us why this situation, which in almost every other contact would be extremely adversarial and probably lead to litigation, in your case ended up ending in a collegial business friendship.
Cu mare drag vă răspund la această întrebare.
I will be happy to answer this question.
Activitatea în general de avocat, jurisprudența
Working
implică și
as a
negocieri,
counsel, as a
implică
lawyer, that actually requires
neapărat
having
implică
some
întrebări
negotiation
trebuie să ajungem.
skills,
Deci,
and it's not necessarily
până la
it
urmă,
doesn't have to go to
raportul
litigation as far as
nostru
litigation.
ca acest
We
cred
ended
final
up
așa
reaching some
fi
common
stabilit de raport
ground
de
for
evaluare,
this
poate
final
să fie
price of the
achitată
car to be established by the
ulterior.
Board of
Deci
Assessment, and
că
then to make
probabil mă
payments
gândesc eu
in
că
installments.
această
And then I think
companie
that this
avea nevoie
company
de avocat
perhaps
jurist
also needed
și
a
probabil au
lawyer,
văzut că pe
a
piața mea,
counsel,
probabil au
and
văzut
perhaps they
și
realized that I had the
capacitățile mele de
skill
a
and that I
mă
had
impune în anumite situații
the
și
capacity,
au
the
propus
skill
această
to
colaborare, deci și
impose
ulterior a venit
myself in
această
certain
colaborare.
situations.
Nu
So
e nicio
that's how
problemă în viziunea
we've
mea
then
că
come to the
inițial
point where we agreed to collaborate. It's not like
caz de litigiu,
we
iar
were a step away
deci
from
ulterior am
litigation
ajuns să
and then
colaborăm.
we ended up
Deci
being
aceasta este o practică
friends, or
normală de a
we ended
găsi
up
un numitor
collaborating.
comun.
I think it's
Sarcina noastră
normal
tuturor
practice
suntem
to find
în
common
situația de
ground. It is the
descărcare
task
activitatea
of
instanțelor judiciare, astfel încât
all
ca
of
în
us
funcție de
to
schimbare
unload
să nu
courts, not
deci
to overload them
în
with just
situația în care noi
additional
putem să ieșim cu negocieri, să
cases to
ieșim
litigate about. So if there's a
pe un
possibility
numitor
to
comun,
negotiate
deci
our
asta a
way
fost
out to
folosit
reach common
această
ground,
facultate de a
well, if that
negocia
is
și
possible, then
ulterior,
that's what I
în
made
virtutea
use of.
relațiilor
And
inițial, da,
further
problematice
on,
și
perhaps,
așa mai
yes, it did
departe,
start
am
from
stabilit
more
o relație bună de
adversarial
colaborare
relationship, but
chiar de
then we established
prietenie.
a
Nu
good
văd
collaboration
nimic
relationship. We
bizar sau
even
ieșit din comun în
became
această
friends. I
situație.
see
Ori
nothing bizarre,
viața
nothing
viață
out of
și
the
ne oferă
ordinary. I mean,
dificultăți
life is life, and
inclusiv
you're
și
going to have all
situații.
sorts
Deci
of situations.
eu
So
văd
this was
ceva
just
ca
one of
ceva
the
normal,
multiple situations in one's
ca
life,
ceva
and I
care nu
see
ieșe
this
din
as
comun,
something that
cum
is
am
rather
menționat, prin prisma
natural, not
artei
bizarre,
negocierilor,
not
artei de a
strange.
negocia cu
It is
anumite
through the
persoane
art
și
of
ulterior
negotiation
chiar și
that you
să
can
ajungi la
also
relații normale de lucru. Deci
get out of a
aceasta a fost
situation. It
în
can
cazul
you,
meu
you
și
might end up
situația
having some
respectivă. Și nu văd
work-related
nimic
relationships, and that is
definitiv
exactly
sau
what
să
happened
încalcă undeva
in my
normele,
case. I see
principii
nothing
deontologice
issue. I
sau
don't see any
altceva.
violation of any
Asta e.
ethical rules, for instance. That's all.
Thank you. Let me see if there's anyone else on the commission that has anything to address on this issue before we have Armantis move on to the next topic. Saskia.
Unmute myself. Mr. Besliu, I have one question with regard to the rearrangement of the contract. Let me put it like that, in 2018. And in that contract, you were given the opportunity to take 5 years to fulfill the obligations in the contract. Was this number, this 5 years, was that the subject of a negotiation between you and the seller? How did you come to 5 years?
Cum am menționat și anterior în răspunsurile,
As I have previously also mentioned in my answers, the first annex was because of the defective car, the faulty car, and because of that, we've agreed on what was in the first annex to make the payment in installments, that is. Then, given that we were already having in 2018, we became friends by that time with the director of the company. I've asked for him to understand my situation and to allow me that deferment, because I was accumulating funds to purchase real estate, and I bought it in 2021. So there was this logic behind it. It is all tied in well together. And my request, what I've asked for, and the agreement that we reached with the company reflected that. And in 2023, I had paid for that car. I don't see a problem around the payment for the car up to 5 years. It is the agreement of the parties, and that was reflected in the contract. If the contract reflects this agreement of the parties, these arrangements, if the parties agreed to meet each other halfway, given that I would have also been able to demand for some penalty, as I've mentioned, and they've agreed with that with the installments, and as per the first annex, and then we had that friendly relationship with the owner. Then we had the third annex where we've agreed to pay by 2023. So I don't see that there's a problem, and there is nothing in contravention of the law. This is a normal practice when the parties agree on how to pay for certain things. And I would like to reiterate that I had paid the entire amount for that car. There is no claim against me, for instance.
Excuse me. You are repeating your answers and you're not answering my question. Why was it 5 years? Am I to understand that you came up with the proposal to defer the payment for 5 years and the seller accepted?
Da, vă spun de ce 5 sau 5 ani. A
Yes,
fost
well, I will
inițial
tell you
până în
why it was 5 years. So initially it was until 2018, then 2018 to
No, that's
2023. So
not what I'm asking. I'm
Da,
just
datorită
asking you, was it your proposal for it to be 5 years and did the seller accept it? Or was there a
am
negotiation?
Da, am solicitat vânzătorului
yes,
ca
I
să încadre
asked
această vacanță
the
de piață,
seller to
datorită
allow for
faptului
that
că acumulam
deferment
flux financiar
because
din
I was
pentru
collecting, I was
immobile,
accumulating
care m-a
funds to
impresionat în
pay for the real
2021
estate
și
that I
crezut
bought
că
in
speriem ca
2021.
să acumulăm
And I
câteva
thought that I
flux
would
financiare pentru
manage to
imobile,
collect
o să
funds
cumpăr
thus for
imobile până în
the real
2023,
estate, and
o să mă
then
achit
then
inclusiv
by
cu
2023 I would
imobile.
manage to
Asta a
pay
fost
the
logica,
amount I
deși
had to
au
for the
fost
car.
5
So that
ani
was the logic in my head
convenit de comun acord
behind
cu
the 5
directorul
years, which
companiei, care,
was
da,
agreed
l-am
upon
rugat
with the
fixând
owner of the
situația mea,
company. I
băi,
asked
dumneavoastră,
him
uite,
to
foarte
understand
l-am
my
rugat în spatele
situation, and
meu,
he
deci am
agreed,
amânat
he
acest pas.
understood me, and he allowed for that
Thank you.
deferment.
You asked my question. You asked for 5 years and he agreed. Correct?
Da.
Okay.
Yes.
Let me see if any of the other commissioners would like to join in at this point. Okay, Armantis, the floor is yours. To continue.
Thank you, Mr. Chairperson. So the second group of questions related to non-declaration of debts for purchasing the BMW 520D car in 2021 and 2022 annual declarations. So according to information available to the Commission on 24th July 2017, you signed an agreement on the sale purchase of the BMW 520D vehicle. The agreed price was $355,000. The first payment of $40,000 was made in March 2017 after the pre-contract was signed. On 1st September 2018, the contract was changed and the parties agreed to postpone the payment of the rest price until 31st December 2023. You paid the total cost for the vehicle in 2 installments in 2023, as you mentioned today, $95,000 on 17 July 2023 and $220,000 on 18 August 2023 for a total of $315,000. You submitted annual declarations of assets and personal interest in National Integrity Authority for 2021 and 2022. On the submission date of these annual declarations, your debt was $315,000. In the annual declarations, you mentioned the property right on the BMW 520D vehicle worth $355,000. However, you did not indicate the debts for this car in both annual declarations. Is this information correct? If yes, please explain why you did not declare the mentioned debt.
Da, onorat comisiei, deci cu regret după
Yes,
întrebările
Honorable
dumneavoastră, am
Commission,
constatat că nu am
after your questions, I've realized that I had not declared that debt.
debt.
And that was because, first of all, I was not experienced with filling in these declarations. It was an omission. It was an inadvertent omission in this particular case. It was not done on purpose as regards the non-declaration of this debt for 2021 and 2022, but that was out of lack of experience to fill out declarations like this. I did not pay attention, I guess, to that particular compartment, to that particular field, when I did not introduce the debt there. That's why during the Q&A sessions, I've admitted to that, and I regret it. After the questions I received from the Commission, I realized that indeed I failed to report this debt, what I was supposed to. But I must also mention, Honorable Commission, that it was not done with intention. It was not my purpose. It's worse when you don't declare your income, for instance. But in this case, I've only did not declare a debt, but it was just an omission on my side. And then there is a decision of the Vetting Commission from 28th of March 2024, where, for instance, the candidate did not also submit a debt of a debt in a declaration for 2015. And in my case, I believe I just did not fill in something in just a particular compartment or chapter of the declaration. I think this is not as bad as for serious doubts. For instance, I did pay the entire amount for that car at the end of the day, so I don't have debts now, and I do admit to not having declared that when I was supposed to.
Thank you for your explanation. Another question. So according to information available to the Commission, in 2019, you granted a loan to your ex-wife in the amount of 2,000 euros. This loan was not indicated in Chapter 10, expenses of 5 years declaration. Could you explain why you not declare this loan?
First of all, that loan was granted by my parents, not by myself. My parents gave her that loan. And I have already mentioned that it wasn't me, that it was the parents who gave that loan, so I couldn't have declared it because it was not my obligation to, and it's only through me that the money was handed over, but she sought or she asked for that loan from my parents, not from me. So that is my clarification.
Thank you. According to your annual declaration for 2018, 2019, and 2020, your residence address was in Chisinau municipality, Stulcheni, but you didn't mention any ownership rights or other types of use. The immovable property located at the address of residence belongs to your father. Also, according to information available to the Commission, Sergiu Besliu Law Office has the same legal address. Is this information correct? If yes, please explain why you didn't declare the use of mentioned property in your annual declarations.
As I've already mentioned, first of all, I would like to make the comment that these issues were not raised in the list of doubts. I would have prepared and thought through my answers, and I would have looked back at my previous answers, but in this list of doubts, I haven't seen this as an issue. But I will answer nevertheless. Yes, that is a domicile of my parents, and as I previously have stated in the questions and answers rounds, it was an omission. There was the right of habitation that I was supposed to declare, but I didn't. At that time when I've established the lawyer's office. And this is because I had to fill out quite fast these declarations. I did not also have this practice, this experience of filling out declarations like this. So that's why I did not declare this right of habitation in my parents' house, though that's what I've lived my entire lifetime. So I have nothing else to mention in this regard. I did not report it, and it's an omission on my behalf. The fact that I did not declare the right of habitation at that address in the 5-year declaration because of lack of time, and it was a little bit neglectful because I had to hurry to fill out those declarations. So that is the reason why I did not, but I've lived there for a very long period of time.
So it was the last question regarding declaration. So maybe you have something to add or clarify concerning this issue.
No.
Maybe other commission
Nothing for me
members
to add.
want to join and ask some questions regarding this issue.
It looks like there are none, Hermontis, so continue.
Thank you, Mr. Chairperson. So the third group of questions related to income from the car model BMW 520D car rental in 2018-2021. So according to information available to the Commission, on 1st January 2018, you and your Sergiu Besliu Lawyer's Office signed a lease agreement for BMW 520D car. You signed the contract as a person and representative for the lawyer's office. Your lawyer's office paid you for the rent 192,000 MDL in 2018, the same price in the 2020, and 75,000 MDL in 2021. In total, 459,000 MDL. Estimated 23,000 euros. On 31st May 2021, the lease agreement was terminated. Is the information correct?
Да, есть корректно.
Yes, it is correct.
The total price of the BMW 520D car that you were supposed to pay was 355,000 and there. Is this information correct?
Да, есть корректно.
Yes, it is correct.
You defer that payment for the car for 5 years. Is that right?
Да, корректно.
Yes,
Mhm.
it is correct.
In your opinion, was the rental price economically reasonable for your law office?
Да, Honorable Commission, am să dau careva explicații.
I will provide some explanations, Honorable Commission.
Deci, în cazul respectiv,
In this
amintitor
case,
că, într-un fel sau altul, pe un termen mai lung,
it was mentioned that
urma să
one way or
fie mai mică.
another, for instance, for a longer time, the rent was supposed to be smaller. I have carried out a research, an open source research. I've looked up information on these websites for car rental, and that agreement was not above the average price for car rental. For instance, according to Matrin's website, MT, a BMW 5th Series 2009 E60 model for 365 days, 10,000. Excuse me. I just asked for the amount to be repeated. 210,156 lei a year. And my car was 192,000. And that car on the website was from 2009. So it was an older car than mine, and that was above 210,000, and mine for 192,000. And then a different website, again, another BMW from 2018 for a year, 1 year, for the price of 223,000 lei. So that means that there's a car from 2018 who is 6 years old at this moment in time, and my car too was 6 years old at that time. In this particular case, a 6-year-old car is actually being rented out in a year for a bit more than 400,000, in fact, and that the price I was paying in 2020 was 192,000. Then Just Rent MD for third series, a series that is lower than number 5 for from 2014. So the car is from 2014 for 1 year, 365 days, 14,000, a bit more than 14,000 euros. So actually, my car is 1 year older, and the 5th series, and that again, the price was only 192,000 a year, and that is indeed smaller, even to this day, that is smaller than what you can see on the market. So that is certainly not above the average on the market. Eurorent Cars MD is another website. Cars are rented out, similar cars from 2019, 6-year-old car, 315,000 lei a year, and then I go back to mine, which was 192,000 a year. Rent Cars MD rents out similar cars to mine, but just 1 year older. The 5th series from 2012 for 1 year, and the price is 245,000 lei. And then again, my car, 192,000 lei. Similarly, there is Cars for Rent.md, another website renting out similar cars or cars similar to mine from 2013, so practically as mine at this day, 280,000 lei a year, that is their rent. And mine for 192,000, which is under the market value. And I've already also explained the commission. And I've also sent the commission, as part of the rounds of questions and answers, I've sent 2 requests that I've showed, that I've 2 requests that I had from other companies that are renting cars out. So there are companies that have this website, that own the website Just Rent, for instance. So I've asked for information from them. So these companies responded to my request, and they stated that a BMW of 2012 that is 1 year older than mine, the price for that is 12,600 euros a year, for instance. And then there was another car, the AJ car just rent. They've communicated to me that that a car from 2018 is being rented out for 18,000 euros a year, but the price for my car would be established at around 9,000. So practically, the price that I was charging was not above the average back in 2019. So to this day, even that amount is not bigger than the average for the market. So it would not be unreasonable from my point of view. This agreement, this contract is absolutely reasonable and fair. And this is a practice that lawyers do. They are renting cars and they use those cars for work purposes, to travel around to court, to see their customers, to criminal investigation bodies. So a car is being used for work and to be able to provide legal services. And that was the reasoning behind it, and concluding that sort of an agreement. And I would like to reiterate that the average amount of rent per year was not exceeded, looking back at when the contract was concluded, that is January 1st, 2019. So for that period, it did not exceed the market average. And I do not think the contract was unreasonable. I believe it followed the general practice as per the market values that used to be valid at that moment in time.
Thank you for your explanation. So, if I understood you correctly, you confirm that rental price matched the market rental price at that time. Is that correct?
No,
I don't confirm that it coincided, that the market price at the time in 2019 is not the same. It did not coincide. The price that I've established in 2019 is under the value of the market value at the time and now, which means that it is very reasonable for a car rent price. This is not this is not contrary to the law. This was established by agreement. The payment was made from the office of the lawyer to the individual Besliu Sergiu. The amount was paid for rent, and it shows that Besliu Sergiu has paid even income tax from this rent. So I see no issue in terms of a violation of the law. There was no violation of the law. It was all drafted properly in line with the law.
Thank you. Please explain how you estimated the rental price when you signed a contract in 2018.
I can provide an explanation as to that. I've looked at the average for rent in that period of time in 2019. I've looked on websites, I've looked at information up, and I've analyzed it, looking at cars of that same model year, and I've made some calculations to have an average, and even that back then I've established that it's best to have a price that is under the market average to avoid anyone raising any issues or questions, for instance, as we are having these questions right now. But the price was certainly established in a way that was under the market average. And at that time, I did do my research, the car market. I've established it not out of a whim just because I wanted to, but I've analyzed the market, and I've shared that rationale with the Commission post-hearing. In a fifth round of questions, I've explained very clearly what the rental amounts are currently for similar cars. For instance, 6-year-old cars at a particular point in time, cars like mine, for instance, would be rented out for higher prices.
Have you considered other car rental options at a lower price?
Deci eu cum reiterez ceea ce am menționat, eu am
Well,
făcut o
I would
analiză
like to
cu
reiterate what I've already stated. I did conduct some analysis and I've looked things up, and the rent that I've asked for was lower than the market value, about 27 euros a day. But in that period, one would pay 35 to 40 a day, and for that same type of car. So it was already lower than the market value. It was the reasonable. It was not one that would be above the average. So I believe it was all fair, my analysis, the way I've established it, and then that was reflected in the contract.
Thank you. Did you use this BMW 520D car for your professional activities as a lawyer in 2017, 2018, before signing the rental contract in 2018?
Probabil, acum nu mai țin minte, dar probabil în calitate
I
de
can't remember
comodator.
very well now, but I guess it was a loan for use, like commodatum. I was using it.
Este un
I was
serviciu evident.
using it for work purposes, obviously.
After signing the rental contract in 2018, did you use the vehicle for your own purposes, not for lawyers' professional activities? And if yes, how was it paid for the use of the car?
Am utilizat automobilul respectiv în scopuri
I
profesionale.
have used
evident,
it for professional purposes, certainly for professional purposes only after 2019, and I've been using it to this day. I've been using it for professional purposes, for work.
But question was, did you use vehicle for your own purposes, not for lawyers' professional activities after 2018?
Nu,
Lui de avocat.
în scopuri personale eu nu utilizez automobilul.
I don't use the car for personal purposes. Since I have a contract, it's used for the contractual purpose, for the lawyer's office activity. That's my activity, and the car is exclusively for my professional activity.
Thank you. When you concluded and terminated the lease contract, were you aware of the tax rate for the individuals and persons carrying out professional activity in the justice sector for 2018 and 2021?
Deci la momentul respectiv eu nu cunoșteam sau nu eram
At
interesat
that time, I did not know, I was not interested to find out the rate for individuals. I was interested in my lawyer activity, and I needed to make sure that it has to be legal. So I knew it was 18% for lawyers. So I knew that for lawyers' activity, it had to be 18% tax rate. I was not interested in other categories. I was not interested in finding the rate for individuals or other categories of taxpayers. I was interested in the activity as a lawyer that was supposed to be taxed at 18%.
Thank you. According to the Code of Ethics for Lawyers, the relationship between the lawyer and his client is based on honesty, probity, and fairness. The lawyer's responsibility also includes his conduct in the exercise of the profession and outside it. Did you follow the principles of fairness when you signing the rental contract?
Locațiune.
Desigur că am respectat.
Yes, of course, I follow. I analyzed the legislation. I analyzed all the circumstances in that case in order not to having them contradictory to certain matters. Again, renting the car was a normal practice among attorneys. Lawyers rent cars, they include it in the expense reporting, including the bookkeeping. I don't have an accountant. I keep my books on my own. I don't believe I violated any ethical rules by signing that rental contract. It's something normal for lawyers. I don't see any contradiction. I followed all deontological rules for lawyers when signing that contract. Moreover, whether if tax documents are not signed or tax is not paid, no, but it was all signed and paid. So the contract was signed, taxes were paid, money was transferred to the individuals paying taxes. So it was all in line with the law. I did not act in violation of tax law, both as an attorney's office and individual, because I paid income tax as individual for the rental. I did not mislead the state. I did not try to lie to the state. I paid diligently all the taxes according, and I drafted all contractual obligations in line with the law.
Thank you. Why did you decide to terminate the contract in 2021?
Да, vă spun despre aceasta.
I will tell you about that too. In the end, I found that it was a difficult, a troublesome practice to conclude purchase documents, to pay the individual, to pay taxes. After 2 years, 2.5 years of practice with that rental, I found that it was inconvenient. You know, I was at my beginning of the pathway as a lawyer. I got my license in 2017. In 2019, I concluded that contract. I wanted to try that way of working for an attorney office with that rental, but then I reached the conclusion it was quite difficult and troublesome to continue the practice, and I terminated the rental contract in 2021. I think it was May or June, if I'm not mistaken.
Thank you. Starting 1st June 2021, you have concluded a bailment contract between yourself as an individual and your Besliu Sergiu law office to continue for free use of the BMW 520D car in the law office interest. Why did you continue using the mentioned car for your professional activities for free?
Cum am menționat, deci
As I mentioned, I believe for me it was a difficult practice to pay the taxes as an individual, to order procurement documentation. So it was just an attempt for me to try to vet contract, and then I tried to work with the rental type of agreement. I understood it was a difficult procedure, not having an accountant, and it was more difficult to calculate all the taxes all the time. So I decided to terminate that contract, and I continue to use the car for professional purposes under a bailment contract.
So thank you. Do you have something to add or clarify regarding this issue?
Deci, nu, asta este ideea.
That was the idea. I said what I needed to say. On this issue, I don't think I violated any deontological rule. Everything, the contract was drafted correctly, taxes were paid, so to the taxes to the state, I paid rental payment to myself, so I don't think I violated any deontological rules.
Maybe other commission members have questions regarding this issue.
Looks like Virginia does. Virginia?
Mulțumesc, domnul președinte.
Thank you, Chairperson. Mr. Besliu, thank you very much for your very detailed answers. I have two clarification questions about the declarations filed by you as an attorney on behalf of Sergiu Besliu Attorney Office, and if you filed declarations as a citizen, given the income that you obtained as an individual from the rental of a car.
Cu certitudine vă declar că am depus atât în calitate de avocat.
confidently declare that I filed the declarations as an attorney, and I also the declarations chat 15 and chat 18. I think I provided them in the first or second round of questions. The Commission has these declarations of mine. If needed, I can provide them repeatedly. I filed declarations both as an attorney office, as an individual that was beneficiary of rental payments, and it was mentioned in chat 15 and chat 18 declarations. There's an express mention that it was income from rental, and taxes were paid. If you let me, I can tell you, I have bank statements that were submitted to the Commission previously, and in the necessary fields in the, I think in the last post-hearing round, that there is a comment on what point from the bank statement is a payment of tax by me to the state in relation to the rental of a car. I reiterate, I declared both as an attorney and as an individual. Thank you. So these amounts that you paid as an attorney office to citizen Sergiu Besliu are reflected both in the Dash declaration of attorney office and in the chat declaration. Yes, they are declared. I can search for them now. I have them with me, but they are certainly declared, and the Commission has access to them. Thank you. Now, by offering detailed answers to the Commission, you said that given that you paid all the taxes on that amount, you are not interested in other taxes that would be applicable to other categories, if I understood you correctly. Then, when you filed both declarations, you probably saw, or if you didn't see, then confirm that you didn't, but there is a difference between the tax applied to an attorney office and the tax applied to the individual. Yes, let me explain that as well. First of all, I concluded the rental agreement on 1st of January 2019, and at the date of signing, I did not know. I did not know about the different taxation rates for attorney and for individual. But later on in 2020, when I had to declare for the year 2019, when I made the declarations, that was 12%, or how much was that for the individual? And in March 2020, when I declared for the year 2019, I declared the income as an individual. So I studied the situation and I saw that indeed the individual is taxed at that rate at that time. But that happened only in March 2020. That's the idea. I understood you. Thank you.
If there are no other questions, or Montes, you'll proceed with questioning.
Yes, thank you, Mr. Chairperson. So the fourth group of questions related to the alienation of immovable property belonging to your cousin Irina in 2021. According to information available to the Commission, you provided legal services to your cousin Irina in 2021 as a lawyer. Your cousin Irina issued you a power of attorney to represent her interest in accepting the legal inheritance and alienating the share of the legal inheritance. On 13th January 2022, you, on behalf of cousin Irina, signed a contract for the real estate division by which Irina alienated inherited immovable property with the amount of 24,308 euro. Subsequently, on 22 July 2022, you, on behalf of cousin Irina, alienated the inherited garage for 2,000 euro. In total, you accumulated from the alienation of these assets 25,808 euro. In 2022, you are part of the amount from the sold immovable property 4,140 euro transferred to cousin Irina through the Western Union remittance system. Is this information correct?
Yes, it is correct. It is true.
Thank you. According to information available to the Commission, you did not declare income received on behalf of cousin Irina to tax authority, the National Integrity Authority, or to the Commission in 5-year declaration. Could you explain why you did not declare such income?
Da, onorat comisie, pot să explic.
Distinguished Commission, I can explain.
Dat fiind faptul că am contractat,
Given
deci am
that
fost contractat
I
și am contract
was
de asistență
contracted, I
juridică
have
cu
a
Irina,
legal
în
support
cazul respectiv nu
contract
am,
with Irina.
deci nu
In
am,
this
nu a
case,
fost necesar să declar
it
aceste sume,
wasn't
dar
necessary to
este o sumă de
declare
bani
these
care
amounts
vine din
because that is
activitatea
an
profesională de
amount
avocat și nu din
coming from a
activitatea,
professional
banii
lawyer
mei personali.
activity, and it's not
În
my
cazul respectiv,
professional money.
deci nu am
In
avut
this
pentru ce să
case,
declar aceste
I
sume,
did
ori
not
sumele respective au
have
fost obținute,
to declare
transferate
those
în interes
amounts
terțului, în
because
baza
the amounts
contract de
were
asistență juridică
transferred
de procură.
for
Deci,
the benefit of a
nefiind
third
banii
party
mei
based on the
personali,
legal support contract and
fiind
the
din
power of
activitate de
attorney. It wasn't
avocat,
my
deci
personal
nu am
money.
considerat că
It was
urmează să
based on my
declarați.
attorney
Ei
activity.
sunt
I did not
strict,
believe I had to
deci în
declare.
bază de
The
contract
money
obținut
is
din
still
cota
is
din
strictly
străinare cu
based
efectuări
on
succesorale a Irinii.
legal
Și
support
nu,
contract
deci nu
from
sunt banii mei
alienating
personali care însă eu i-am depozitat.
Irina's
Și
inheritance. It's
respectiv
not
îi
my personal
transferam, și
money. So
transfer
I
deci
was
la necesitate
transferring and
când
I'm keeping
solicită
transferring at
dumneiei
need when she's
pentru,
asking.
deci am transferat aceste sume.
I transferred
Asta
some
este
amounts.
explicația de ce nu am declarat. Nu
That's the
eram, consider
explanation
că nu eram
why I did not
obligat și
declare. I believe I was not
respectiv
obliged to do
provin din
so.
activitatea profesională
These
de avocat,
amounts
nu sunt
are
banii
a
mei
result of
personali, nu
my
este un bun,
professional
nu
activities
de
as an
mine,
attorney.
nu
It's
pentru
not
mine sau în numele meu,
property
ci un bun
sold by
vândut
me
în numele
on behalf of
și
me
pentru Irina.
because it was sold on behalf of and for Irina.
Thank you. In written communication with the Commission, you explained that the remaining 21,668 euro is kept in cash with you. Is this information correct?
Da?
Yes.
Do you still have this money?
Deci nu continui să dețin în mare parte, deoarece au
I
fost
don't
transferați
still have it
pe parcurs,
mostly because
inclusiv au
they
fost
were transferred
transferați,
over time.
deci suma respectivă, deci
That
s-a mărit,
amount was
nu a rămas la 4.000, cursul mai fost transferat bani.
the
Deci,
amount
iar banii
increased from
respectivi care au
4,000,
rămas,
so more money
îi
was
dețin
transferred, and the
numerar
amount
și la
left I still
solicitarea
have in
dumneiei,
cash,
eu
and
imediat
at her
expediez
request
banii
I
respectivi în
immediately
țara
send
din
her
se află.
the
Deci,
money to the
asta
country
este
where she's now.
explicația și
That is
nu
the
văd o problemă, cum am
explanation.
menționat,
I
aceștia
don't
nu
see a
sunt banii
problem.
mei,
As I
dar
mentioned,
ci
this is
sunt
not my
doar
money.
niște bani
This
proveniți
is
din
just
activitatea
some money
profesională.
resulting
Că
from
eu,
my
evident, că
professional
îi
work.
dețin la mine, parcurs,
And of
până
course,
o să
I keep
expediez
the money over
deci
time
solicitantei, în cazul
until
dat. Și
I
dumneiei a
send
scris
them
o recisă că a primit
to her.
acești bani prin poștă
And she
expediată, deci
wrote
nu pot să o
a
prezint
receipt
comisiei, nu-mi cer
that she
copii, mai
received the
departe, la nici
money
subiect.
and
Deci
how she used. So
a fost
I
tot
can provide
transparent
that
și
to the
corect.
commission. Everything was transparent and correct.
Thank you. According to the legal service contract of 5th February 2021, the lawyer's fee was set in the amount of 10,000 MDL, which should be paid within 30 days from the moment of complete execution of the lawyer's obligation related to acceptance of the inheritance for the beneficiary, the alienation of the estate on behalf of the beneficiary, as well as the transfer funds to the beneficiary following the alienation of the beneficiary share in the inheritance. Have you got the lawyer's fee according to the contract? If yes, one.
Pot să declar că nu am primit onorariu, ori
I
conform
can
contractului.
state that I
clauzei
did not
contractuale
receive
referitor la
because
onorarii care
according,
plătit-o chiar acum, acolo se menționează și
according to the
inclusiv
clause that you
după
have just
transferarea
read, it
tuturor
says that
fondurilor.
it's also after the transfer of all the funds. Not all funds have been transferred yet, so my obligation in relation to this contract has not been fulfilled fully yet, so I did not receive my fee yet. And after all payments are done, after I transfer everything to her, she will pay the fee.
According to the same legal contract on 5th February 2021, you had an obligation to transfer funds to your cousin Irina. You have not transferred funds until now to cousin Irina and have not fulfilled all contractual obligation. Could you explain why you have not fulfilled the contractual obligation?
Nu, mi-am îndeplinit obligațiile contractuale.
I fulfilled my contractual obligations because a contractual obligation consists of several parts: accepting the inheritance, alienation of real estate, transferring the money. As I mentioned in the written communication, when needed, when she's asking, I'm sending her money. Periodically, I fulfill, well, in the sequence, my contractual obligations, and so far I did not have any situation of not fulfilling them. So when the respective person asks for funds, I send her the funds. I fulfill diligently my contract. So as soon as the last part of the money is sent, the fee will be paid.
In your opinion, do you have legal grounds to keep funds of alienated immovable property for such long period? Did you follow the principles of the Code of Ethics for Lawyers?
Again, this is an agreement between me and the client in this case. And in this case, the client gave me indications, and that according to my client's indication, the money is held by me. And it's not contrary to the Code of Ethics that the money is kept by me. Moreover, at the request of the client, I send her periodically the certain amounts. I don't see any violation here. The fact that I hold these amounts and I don't send the amounts, it's done because the attorney acts upon indication from the client, and the client said that I need to send the money when she requests that.
And finally, thank you for your very detailed answers. Do you have something to add or clarify regarding this or other issues?
Nothing to add. That's it.
Maybe other commission members want to join and ask some questions regarding this issue.
Yes, I think Nadezhda has her hand up.
Yes, thank you. Domnul Besliu, eu aș vrea
Mr. Besliu, only if you can explain once more, because I did not understand it entirely. Why your cousin asks you periodically for money and not for the entire amount? Was that an agreement from the beginning? Is that a clause in the contract, or was that an additional agreement of the contract about this way of transferring the amount for which you sold the real estate? Thank you. That's an understanding between me and my cousin. When she needs the money. So she wants sometimes for me to transfer her certain amounts, and it was her will for me to transfer the money periodically. It wasn't provided for in the contract. It's an understanding between the two of us that periodically I am going to transfer to her this amount. So I do that according to her request. It's the client's will, agreed by us, because we are cousins in the end. So, and if she wants to do things like that, I am trying to help her like that, because in the end, this was also a help for her from me, because the attorney fee was also very symbolic. It's small, and in order to accept the inheritance for her, not to need to come back to Moldova. She is abroad. She has not been here for a long time, and not to making it difficult for her to come to accept the inheritance, because the procedure is quite complicated, and they should have to spend a lot of time in Moldova to do all of that. I undertook all those measures for her on her behalf, and we amicably agreed that the amount should be, the money should be sent when she requests. Well, if I understand correctly, that's the client's will, which is not provided for in the contract. It is an additional clause that you agreed verbally. Is that right? Yes, it's the client's will, as I said. We are relatives, we are cousins. This is what she wanted, this is what I'm doing. When we concluded the contract, when on the 5th of February, when we concluded the contract, we did not decide that it would be in parts or in full. I couldn't have provided for everything in the contract. It's the situation that she wants for these transfers to work like that. I comply with what she wants, and I send her money periodically when she asks for it. But do you agree that from an economic point of view, it doesn't make a lot of sense? If she were to put that big amount of money in a bank, should have obtained some interest. But in this case, I mean, it's the person's choice. She does not trust banks. It's a person's choice. Certainly, I don't know if she trusts banks or not, but it is her choice. As mentioned, I sent her and I had received that she received some amounts, more than 4,000 that the commission mentioned. I sent all the time at her request some more amounts. So periodically, amounts are sent at her request. That is what I can say. This is what she wanted. His client's will. The attorney cannot go against the client's will. Thank you. No more questions.
I have just a few clarifying questions. Mr. Besliu, if I understand your testimony correctly, you're still holding some amount of cash for her. Can you give us an approximate amount of cash?
Approximately, I probably have around 5,000 euros, around 5,000 euros, because all the time I sent her more amounts. So I sent until now, I have sent around 19,000 euros in the context of the legal support contract with the inheritance that she received. So I sent her over time this amount. So at this time, I don't hold for her a big amount. It's 5,000-6,000 euros.
And is this in a bank account or an escrow account, or is this in cash somewhere?
It's cash. Obviously, it is cash. That transaction was paid for in cash. The buyer of her part and of the garage paid in cash. So I kept the money in cash. I still keep that money in cash. The money is not placed with any bank. And from that money, periodically, I'm sending her, at her request, I'm sending her some amount.
And is that an arrangement she agreed to, that the money would be kept in cash rather than in a bank account?
Yes, she agreed to keep them, for me to keep the money here in Moldova so that I could transfer her money. Sometimes when she did not ask for a bank account. She did not want to earn money from this money. It's money from inheritance. I periodically transfer money when she asks for, when she wants it. There's no subtext here. With interest, without interest. She trusts me, I hold the money. When she asks for money, I'm sending the money. And this money results from real contracts, from that division of inheritance and sale of a garage. This is money according to the transactions that were concluded. And you saw I provided the contracts to the commission. Nothing to hide. It's just, indeed, I keep this money in cash and I transfer periodically. That was agreement between us. We are relatives, we are cousins. I reiterate that. This is how we agreed, this is what she wanted, and I confirm that being a lawyer.
Thank you. At this point, let me ask my colleagues if anyone else on the commission has any further questions on any matter at this point. Saskia, is that a hand raised? Yeah. Saskia, you need to unmute yourself. You're muted.
Yes. Mr. Besliu, I had a good look at the contract that you closed with your cousin, and it's very clear. It's very clear on what you were supposed to do with regard to selling the real estate and about sending the money to her. And I would say that this defines your legal obligations to your cousin, your client. Is that correct?
În baza contractului respectiv, definesc că
Based on
obligații, însă eu la momentul încheierii
that
contractului
contract
respectiv, eu nu
defines
puteam să
certain
prevăd
obligations,
că
but when
eu
we
să dorească
concluded that contract, I
tot în
could
part
not
sau
have
ceva genul
foreseen
ăsta.
that she would
Deci
want the
scopul
money
era
transferred
ca să
in
putem,
parts.
deci,
The
moștenire, deci
purpose
să obținem moștenire,
was
certificat
to
de moștenitor,
obtain
să
that
înstrăineze
certificate
careva
of
bunuri. Deci inspectorul la bani nu spune
of
problemă cum să fie
inheritance
transferat
and
acel bani,
to be
deoarece
able to
prevede
sell
încredere
that
de
it
plină în
though
mine
it
că
wasn't
acești
a
bani o să-i
question
obțin.
about how we
Deci
should
asta era
transfer the money.
întrebarea.
She
Și
had
banii au
full
fost
trust in me
transferați periodic,
that I
mă
would
interes.
have obtained
Deci
the money,
nu-i
and
nicio,
I sent the money over
deci
time.
nicio
I
problemă
reiterate
de
that
integritate
No,
sau
I'm
it's
going
there's
to.
no integrity issue.
You give very, very long answers. Please just answer the question. You said, yes, it was ruled by the contract, but then we changed the contract. Is that correct? You and your client agreed to change the contract, which made it possible for you to keep the money. Is that correct?
Deci am avut o înțelegere din partea
We
dumneiei, a venit propunerea ca să
had an
transfereze acești bani,
understanding. It was her
să se
suggestion
expedieze
for me to
periodic.
keep the money
Asta e.
and to send her the money periodically.
So you
That's it.
changed the contract, you agreed to change the contract so that you could keep the money instead of sending it to her. And sending it to her at a later date. Is that correct?
Din câte eu țin minte,
From
în
what
contract nu
I
este prevăzut
remember,
deplesc,
the
transferă
contract
suma
does not say
integrală. Acolo
explicitly
probabil
that the
acum
amount
nu
in
minte
full
cât
is to
este
be
prevedere
transferred.
din
Now I
contract,
don't
dar
remember
acolo probabil se
precisely
menționează că
the
să
contract
transfere
clauses,
sumele
but it
bănești.
says that
Dar nu scrie în
the
ce
attorney
perioadă, nu
is to
scrie în
transfer
ce
the
dată, nu
amount, but it
scrie,
doesn't
scrie
say
o clauză
within what
generală. El
timeline, on
ce
what
fac?
date.
Transferă
It's just a
aceste sume
general
bănești.
clause.
Deci
And
eu
what
nu
I
mă
am
înscrieți
doing,
la
I am
transferarea lor.
transferring those amounts. I
Plec,
don't
către mine nu are careva pretenții în
avoid
cazul, da?
from
Mai mult
not
atât, nu
avoid
era
transferring. The
necesar
client
de
has no claims towards
schimbat
me.
contractul
Moreover,
care
it was
clauză,
not
ori contractul
necessary
respectiv
to
era foarte clar. Eu
change
urma
the
să
contract
transfer
because the
aceste sume.
contract
Când,
was very
cum,
clear.
în
I
ce
had to
perioade, deci
transfer the
urma să...
amount, but
Nu
when,
cunoșteam
how,
cum să
in what
transfer eu
period of time, we
imediat
did
aceste
not
sume
know how
după
exactly I would go.
obținerea acestor
I
sume.
was
Spune, am
going to
încheiat contractul în 5
transfer the
februarie.
amounts after I would have
Bunurile imobile s-au
obtained
vândut abia în anul
the
2022.
contract when we
Deci
signed it
după
in
aceea s-a convenit să
February 20,
transfere în felul
because
respectiv,
we
periodic.
sold the property
Iar
only in 2022.
clauza
Only after that we
suplimentară, deci
agreed
nu era
on
necesar, deoarece
transferring the money
prevăzut
periodically, and
faptul
this,
că transferă
another
sumele
clause was
respective
not
că trebuie
necessary
să-și
because we
spună
had
dispoziția
one
acelor
about
bani. Și știți ce
transferring
eu
the
făceam?
money, and I was doing that without specifying any timeline, immediately within 10 days or within 1 month or something else. No specific timeline is provided for in the contract so that I would be bound by that with respect to transferring the amount.
I'm not quite sure if I agree with you that the contract as you have signed it with your client that allows you to keep the money for 2 years after you sold the real estate, but we will leave it at that. This further agreement with your cousin that you would keep the money and send it to her in parts on her request. Is this something that was agreed on paper, or was it just done orally? How did you come to this further agreement?
Deci, evident, cum am menționat, suntem rude.
Well, as I've mentioned, we are family, we're relatives. We did not put it on paper. We've agreed verbally, by phone. She called me and we've agreed that this is how we would be doing. I mean, you would be giving me this money periodically, and we didn't draft any document whatsoever. At the end of the day, given that she is my cousin and she didn't have trust issues as far as I'm concerned, so those amounts.
Saying that you are her cousin, but in this relation you are her lawyer. You may also be a cousin, but we are talking about what you were supposed to do for your cousin as a lawyer. Or did you do it as her cousin?
I would like to reiterate that I was doing this from my capacity in my capacity as a lawyer, but also as a family, as a relative, to help her out in her situation. As I've stated, the contract doesn't say specifically how many amounts would have to be transferred. But as per the contract, I did transfer those amounts at her request. The contract didn't specify how much, what amounts, when they were to be transferred. There was no maturity date whatsoever. We then had some oral agreements, and we then never thought that somebody would ever ask us about these arrangement of sending those amounts to her at her request. It's an agreement that I've reached with my cousin. She is also my client, but we've agreed that I will be transferring those amounts like that. This could have been the case with a different client as well, not necessarily with a cousin. If that's what the client would have wanted to, then I would have also done that for them to transfer the amounts periodically. I have proof of the fact that she has received the money, so that is not an issue.
But as a result of the contract, you say you have not asked for the payment of your fees because you say, I'm not finished yet. I have to send her all the money before I can ask for my fee. So you, is that correct? Am I saying
Corect,
it right? You cannot ask for your fee. Yeah?
Da, corect. Da,
That is
corect.
correct.
Urmează să încasez onorariul după
I
finalizarea
would
transferării
collect
summelor
the
plătite.
fee after all the money is transferred to her.
So because you're helping out your cousin, she still owes you the fees.
Este datoare conform contractului,
Yes, she
deoarece eu
owes that to me as per the contract. I've had some expenses. What that fee means covering certain expenses. I haven't asked for anything else. And I don't see an issue. It was a symbolic fee, actually, although she is a cousin, but I did establish a fee for those services, and it is my right, and that fee would be paid after all the amounts will have been transferred, and after I will have fulfilled all of my obligations as per the contract, as we've agreed with her.
So you said you have, over the last 2 years, you have transferred money to her, and you still have around 5,000 euros left. When you send her money, do you send it to her via money transfer, via the bank?
tot prin Western Union, prin
Well, I do that through the Western Union system. That is faster. That's her request, and that's what I do. It is her desire for the money to be transferred via that service.
Thank you.
Ermontes?
Yes, I want to clarify regarding the amount of money that were transferred to your cousin. According to information that we as the commissioners have, only 4,140 euros were transferred to your cousin Irina through Western Union system. You confirmed already this fact today. So could you clarify what amount of money still you have? And do you have any documents regarding transferring of another amount of money?
Da, eu am documente respective de
Yes, I
transfer bancar.
have the documents confirming the bank transfers, the transfer made to that person. And the amount that is left is, as I've mentioned, is around 5,000 or 6,000 euros. I have to calculate because it depends on the commissions as well. She's also undertaken to pay those too. So that is also taken into account, the commission that you have to pay upon transfer. This is my answer.
So in written communication that happened this year, you confirmed that 21,000 euros is still with you. So this information was this year. So, and you confirmed this information today during hearings. So could you explain when another amount of money and how this money was sent to your cousin? It was bank transfer or it was provided money in cash?
Eu am confirmat
I have confirmed about those amounts that I had at that moment in time when the evaluation began. So I've answered your question at that time. And therefore, at that moment, and then throughout 2024, some other amounts were also transferred, 3,000 or 2,000 euros at a time as she would ask for it. So I had initially answered to your question. I stated that in that year I transferred that amount. At that moment in time, that was the situation. And then I don't remember if there are other questions, if I've made other further transfers, but that's as far as I can remember from our earlier communication.
Da. Asta e.
That's my answer.
And
Чисто
my,
особисто. Da.
and my last question, as a lawyer, did you advise to your cousin to put this money in bank account or invest in?
My cousin is an adult, and I believe she can make a choice on her own. I'm not a financial consultant to give her financial advice, as in put the money on a bank account or not. My task was to help her out with the inheritance and to sell the assets. I did not give her any advice as to how to keep her money. I did not make any suggestions whatsoever. She made the decisions on her own as to what to do with the money without being influenced by me in any way.
And who prepared draft contracts that were signed by you and your cousin Irina?
I drafted the contract, and she signed it, and obviously it was me who drafted the contract.
Thank you for your answer.
Do any other members of the commission have any other questions at this point? Mr. Besliu will give you the opportunity to make a closing statement.
Thank you, Honorable Commission, for this repeated possibility to appear before you and to provide further additional explanations. I would like to thank the Commission for the work done for assessing me, and I would like to thank the Secretariat. I've constantly been in touch with the Secretariat to this day, and I would like to wish you the best of luck in what is to come, and the best of luck to everyone.
Mr. Besliu, thank you for your participation today. We will now, as a commission, deliberate on the matter, and so I'll declare that this hearing is now closed.